appears to have talked about funds being put in the wrong account.
I love how you summarize that. You're both here on the Rawsonville South matter, waiting for the ABN and Warren matter. Mhm. I was just calling to ask if you see Mary Ann. I just heard the door open. Thanks. Bye. And there's one from Romulus, Mary Ann, that Marlisa was working on.
Okay.
Thank you, ma'am.
Judge,
Ma'am,
can you please make me co-host?
no,
Pretty please?
I just did that for Mr. Morton. I'm gonna remake you host. I just did that because I wanted to
Go live.
fix this. Yeah,
Thank you.
so you get the feeling when something's going off the rails and you're watching it happen and you can't stop it.
What happened?
This. No, this is that case. This is right now. This is right now, and I'm waiting for the others case. Only one of the two cases is here. You know, this is that two. Yeah. I thought you only gave one case. Well, Jack had taken it off the docket because of dismissal of permit. And I'm like, I didn't even do this on the file, but then I went back. Because this is right, yeah. And then there was a trial schedule for today. Yeah. They came on the 28th. It wasn't, and I was looking for it on Friday. So we were in support for that. We gave it, the attorney was in person. Okay. He should be here. She should be here. Yeah, so Linda is the only one that, is that her name, Linda? Joyce, yeah. She's probably, I don't know if she'll be here or not. She's always got some excuse. Oh, yeah, because she said she's on the staff. She couldn't remember, she talked, or she could come back. We talked, it was fine. And so this time, last time. Because she was doing something she couldn't connect, so we couldn't see her. She had documents that she couldn't show us. And so I said, one of the other, either, and you know, for me, present evidence. Anyway, I just wanted you to catch your breath since you've been up and down the stairs so much. And nobody ever comes up this elevator.
I didn't know how to use it. I get stuck in it, so I don't use it.
How do you get stuck in it?
Well, I don't know what elevator you're talking about, the one down there.
There's one right here.
See, I don't know this one right here. I have no clue that there, because somebody told me there was 3 elevators, and I'm like, there's only 2. There's that one and this one.
When you leave Andy's and you're going to Mariah's, there's a door on the left.
Yeah.
If you go through that door and down the hall to the right, nobody uses it except me and the officers.
I'm gonna have them show me how to use it, but I didn't, because I go in that one, and I go down, and I get stuck, can't get out for some reason, I don't know, so I go back in the elevator, come back up, and I'm like, I'm not using it again, so.
This, I come up so I can turn the
Yeah.
equipment on in the morning
Yeah.
if I have something, if I don't have any.
Right outside.
Right where
the
that door
store.
is?
Yeah.
Yeah, all you need is your badge. I know. I keep telling people come upstairs all out of breath. I'm like, no, you come right here.
I would have used it this time. But yeah, but usually I like to walk up the stairs, but
I've already been up and down the stairs a couple of times too.
yeah.
Get your steps in for the day.
After that, it's like, thank you, Doug.
Yes, ma'am. Marlisa,
Yes.
you came on. I thought maybe Romulus' file was on his way upstairs.
I'm getting ready to send it up. I just wanted to log in.
Okay,
Thank you.
thank you.
For cheese. So you'll have to go there and determine what was.
Good enough.
Have fun.
Good enough, I can say this.
I thought I signed this. Oh, did you? They may have printed it and sent it up. It wasn't checked off on my email. So I really do.
I'll hold on to it, and when you get downstairs, if it's not there, I'll bring it down to you. 254563. I know, that's why as soon as I start saying, I said, what is she gonna? I signed it yesterday
Okay.
and there was an extra copy clipped inside the file.
Yeah, somebody
That
may
was
have
by
done it, they just
email.
didn't check the email off.
This looks like a fax.
No, email.
This was email. Oh, they must have faxed it back and forth to each other.
Yeah.
And we followed up on it because it's scheduled at a time where it was a bad time.
Okay.
So I had Mary Ann call and so they executed and got it over. But yeah, if you don't have it, call me. I'll sign it and bring it down to you.
Thank you.
You're welcome. Thank you. Not yet. We have a live in theory. Yes. At 11. Mr. Morton and Ms. Cooper.
Morning, Your Honor.
This is, good morning, this is 230233LT. This is Rawsonville Woods versus South. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of Rawsonville Woods.
Catherine Cooper with Legacy Legal Aid on behalf of the defendant, PA 5148.
Thank you. While the court was waiting to call the case this morning, the Civil Department brought upstairs a motion to withdraw filed by Ms. Cooper. It's dated yesterday.
That is correct, Your Honor.
And so the question, Ms. Cooper, becomes, because Sandy just handed it over. Was not sure if you had had the opportunity to convey your intentions to Ms. South.
Yes, I did, Your Honor. Unfortunately, it looks like Ms. South has failed to respond to all correspondence that I've sent out to her, so that is why I'm filing the withdrawal motion.
Okay. Before we take that up, I just want to place on the record the following, that there appears to have been an error committed by court staff wherein when the parties last appeared on April the 12th, 2023, on the Register of Actions appeared an indication that Ms. South, excuse me, had posted $3,000 towards the escrow that had been ordered
previously. Subsequent to that date, the party submitted and the court signed an order to release escrow funds to the plaintiff in this matter. Subsequently, the court received a motion in 225328 LT, ABN Property Management versus Randy Warren, which references the fact that the defendant in that case, Ms. Warren, gave to her mother monies to place on deposit in the court's escrow pursuant to another order for escrow. Somehow, inexplicably, the $3,000 for the 225328 case were placed on this 230233 LT matter. The defendant in the ABN property case was able to produce the receipt. When I became aware of it, I asked the court staff to reach out to the attorneys for both defendants, this case and the 22 case, and ask for proof of where $3,000 would have been drawn from on April the 4th, which is the day that or thereabouts, which is the date that the deposit was made, the escrow deposit was made. There is attached to the front of this file a check for $3,000 made payable to Rawsonville Woods in care of attorney Ian Morton. And this court was prepared to mail that out. But as of today's date, the only proof that this court has received regarding the escrow is from the defendant in the 2022 case. I asked the civil department to schedule both cases for this morning in hopes that the tenants will come on, the defendants will come on, be sworn, and give testimony regarding the deposit of this money. This court does not want to release the funds to the wrong person, but now that the 22 file has failed to appear and Ms. Cooper wants to withdraw, I just wanted to make the record clear that this court is striving to do the right thing and get these funds, this release of escrow, to the correct plaintiff landlord. So all of that being said, Ms. Cooper, the question that was first asked was, had you relayed this information to your client? You've indicated on the record that she has failed to respond to communication from you. Are you able to give any help or guidance regarding the deposit of this escrow and its proper depositor?
Your Honor, I don't think that a failure to contact us after she thought that her case was concluded results in her being, in her not putting the funds into the escrow account. I don't think that the other case has any evidence of that. So I'm not certain what
Wait, you don't think the other case has any evidence of what, ma'am?
of the escrow being misappropriated. But once again, I haven't been able to get in contact with her to confirm. So, we're kind of in the dark here.
The issue is that the tenant in the other case, the defendant in the other case, was able to produce the receipt. So, and by them not appearing this morning, it means that this issue remains unclear, but you're here wanting to withdraw. Ms. South is not here. The other tenant, the tenant in the 2022 case, is represented by June Sung, and this court expected those parties to appear at 9 a.m. today for hearing on this release of escrow.
You're right. I believe
And
we have
here's
an
the-
attorney logging in right now, potentially for.
I was gonna say, here's the
yeah.
plaintiff from the other case.
I'm gonna try to run into a different office really quickly because I am aware
Thank you.
that, yeah.
Good morning, Mr. Linnell.
Morning.
This case was scheduled at 9 o'clock. It's 9:22 by my clock.
Oh, I'm sorry. I was told it was 9:30. This is the Bereshai. I apologize. I wasn't aware of that.
This is ABM versus Brandy Warren.
I am here. Let's see. So our client is Bereshai, Barisha
No, sir.
at 9:30.
This is ABM Property Management. I don't have a 9:30. I have two 9 o'clocks and a 10 o'clock.
All right. If you could hold on a second, let me look, Your Honor. I'm sorry. I was just asked to cover this, so a little bit.
Zachary Chewy.
Yeah, from my office.
Yes.
Then that's the case, Your Honor.
Mr. Linnell, you just missed my whole explanation of the fact that there was money deposited, $3,000 into the court's escrow, and it appears that that money may have been misapplied. We're trying to fix it. My hope was that the defendants in both of the related, well, not related, related only through the escrow, would appear and we could take some testimony this morning. Your office has presented the court with a copy of the receipt that was tendered in response to the, no, I'm sorry, not your office. The defendant's attorney in your case presented the receipt showing that they deposited the money, but it was, appears to have possibly been posted to the wrong account. So I was hoping for someone to appear and be willing to swear under oath that they were the depositor of this money, and that has not happened.
I apologize, Your Honor, for being late. I had the wrong time, I guess. Sorry.
Thank you, sir. You're here, Mr. Morton's here, Ms. Cooper's looking for a new location, and I was hoping that Mr. Sung would appear too. My concern is if you were told 9:30, I wonder if he received inaccurate information. I'm looking in the court's file and I see his notice says 9 o'clock. I just would like to get this wrapped up today. Mr. Morton's check is attached to the front of the file and is dated a month ago now. We're just waiting for Ms. Cooper to get back to, I think she was relocating offices.
Yeah, I just need 2 minutes, Your Honor.
Your Honor, I just sent an email to Attorney Linnell with a copy of the motion that was filed by the party. If it might be helpful for him for reference points to know which case this is.
Thank you.
Morton, thank you so very much. Wait, so how did you get a copy of the motion?
I was included in the proof of service.
Mr. Sung was very thorough.
Which is a little surprising why they're not here today.
Exactly.
I apologize, Your Honor. We're in a new office and no one knows where anything is. So I'm sorry.
No worries, Ms. Cooper. That's Tuesday, right? Mr. Linnell,
Yes,
you've had the opportunity to review the motion.
yes. We have no objection to the motion. As I understand it, the money's going to be released to us. That may have been painfully obvious, but just in case.
This is 225328 LT ABN Property Management versus Brandy Warren. I'm concerned that Mr. Sung is not here. I'm concerned that Ms. South, or at least, I don't know if Sandy spoke directly to Ms. Cooper regarding this matter. Ms. South was claiming that she posted this money as well. Correct, Ms. Cooper?
That is correct, Your Honor.
Here's the issue. This case was scheduled at 9 o'clock. It's now 9:29 by this court's clock. Neither Ms. Warren nor her mother, who is the person who is alleged to have presented to the court with the money, or Ms. South have appeared this morning to provide testimony and further documentation regarding who deposited it. But this court's position is that the possessor of the receipt proffers a reasonable explanation for what happened, along with the affidavit of Ms. Smith, who appears. Celia Smith is the one who indicated that she appeared to the court with the money. There is video of the person who appeared, and we had hoped that somebody would come this morning and testify that they were that person. They have not appeared. Mr. Morton, was there something you wanted to say on this matter?
No, Your Honor, I mean, I can't present any proof. My client can't present any proof in regards to who deposited those funds. I mean, was it, we were under the belief based on the hearing that those funds were deposited by Ms. South, but as much as my client would like to receive those funds, I can't, provide any, specific testimony myself, and my client's not here because they couldn't provide any specific testimony in regards to those. It appears that the most important people, as the court's already said, that would provide any supported testimony are not present today.
That being the case, the defendant's motion in 225328 LT being the only documents and sworn affidavit regarding this matter, the court will grant that motion and order the funds be released to plaintiff's attorney forthwith. The secondary matter is the 230233 LT. Mr. Linnell, the court will, if Mr. Sung didn't already attach an order, the court will make sure that those funds get released to your office.
Great.
And then 230233 LT matter, the court will grant the attorney Cooper's motion to withdraw. And then Mr. Morton, your office sent over a dismissal without prejudice of this matter. It was received on Friday.
That was received before then, Your Honor. At least it should have been, but.
Well, it's signed by Matthew Pallas on 5/12.
Okay, well, I
And
know that
received by the office on 5/12. That sounds like Friday to me.
it does. I can tell the court that I know that before, we even had the hearing on the believed escrow funds. Ms. South had turned over possession and had vacated, so the possession portion has been resolved. The reason that the case had continued after that point was because we were resolving the issue with the escrow. And then also Ms. Cooper's communication with Ms. South, which was always, was it a little, was it spotty? I guess sometimes might be the word. So the only thing I would say, Your Honor, is, and I'm trying to locate the order right now, I just want to make sure there's no reference or belief that, or record that would say that that $3,000 was placed towards her past due balance, since those funds will not be received by my client.
The Register of Actions still shows that $3,000 deposited, but I will make the notes clear, and the Civil Department will update it to in fact indicate that the deposit shown at 4/4 receipt number D261882 was in error.
Okay.
And that no funds were released to plaintiff's office regarding this matter.
Thank you very much, Your Honor.
Anything else, Mr. Morton?
No, Your Honor.
Anything else, Ms. Cooper?
No, Your Honor. Thank you.
Anything else, Mr. Linnell?
No, Your Honor.
Thank you all so much for your patience this morning. Have a wonderful day.
Oh, Your Honor, there is something else. My withdrawal motion. I apologize.
I granted it. I signed the
Ah.
order.
Okay. Thank you.
Thank you so much. You all, again, have a wonderful day.
You too, Judge.
Well.
Thank you.
Judge,
Ma'am?
did they bring you the arraignment file?
Yes, ma'am. It's up here waiting for Romulus to sign on.
Okay, I've got to bring you up a new sticky note for the date. I put the wrong one on there.
No, bring it up. You can just tell me. I'm happy, unless you just want to come visit.
I'll come visit. Thanks.
Thank you. I heard you. Give me 1 second, please. What's going on? No, hold on though. Can you do me a solid? Could you? Not gonna let you have it back. No. Wow, really? Really? Is this what we're doing? At least I called before you went on record. Put your hand out to Sandy, please. Of course I will. What time did you tell Riley was to come on?
I told him that I sent to Royce. You know, then to contact Roberts as soon as he was a bit ready to speak with the,
Oh, Marianne, you need to reset me as co-host, please. I've never seen them pop in.
I haven't either. I did get confirmation from Royce that he got my email, because he said, thank you. Or received, thank you, and then,
I was thinking maybe they popped in, I just missed it. No.
I've been looking too.
Whenever they're ready, I'm here. I have a 10 o'clock case, but the criminal case goes first. So if they
Okay,
pop
so
in
I
the
will-
next
I was looking to see the time.
9:40, I'm here. Oh, you know what?
I'll go down and I'll get a hold of Royce.
Walk this way with me first. Hold on.
Morning, Royce. How's it going?
Good. How are you doing?
I'm great, thank you.
Excellent. That's what I like to hear.
Yeah, man. Are you, do you need to talk to the PD or did you already do that?
Yeah, no, I already called them, so they're signing in, but I'll need to talk to the guy in a breakout room.
Okay. How's life? Everything good?
Good. I just got home from vacation on Friday.
Where did you guys go?
Me and the wife left our rotten kids behind and we went hiking in Utah.
You did not. He said rotten kids, Judge. Nelly, I'm so ashamed of you.
Listen, we take them somewhere every year. Last year we took them to Disney. We came home with COVID. This year, or now we went to Utah and we came home healthy. So
It's the kids.
I'm just saying, if it walks like a duck and quacks like a duck, right?
Oh, I'm thinking of too much. I like this one. Hey, so how is the weather in Utah for you guys?
Beautiful, like 75 to 80 and sunny every day. It was
Oh,
just fantastic.
blah, blah.
Yeah, I know, right? Yeah. Then we spent a day in Vegas because you got to fly in and out of Vegas if you're going to Zion, like the national park.
Oh, okay.
Yeah, I have some friends like that I worked with 15 years ago that lived there. So we hung out for a day there. And Michelle, my wife's got her aunt and uncle live there. So we kind of did the rounds and came home.
Wow, how
It's
long
pretty hot in Vegas though. It's
Oh,
already in the 90s there.
oh my God, I can't even imagine.
I
And it's
know.
that dry, well, at least it's that dry heat.
I
Did you
didn't think
gamble?
we did for like a minute, you know. We both took $100 and gambled. We lost it in 3 minutes. Oh,
Oh,
hi.
sorry, you can leave.
No, okay, perfect.
She said you didn't have to come in.
Awesome. Great. See you guys.
Okay, bye.
Yeah, no, we both took $100 and we said, when it's gone, it's gone. 5 minutes later, it was gone. We're like, all right, that was fun.
We're out of here.
Yeah. And my wife, yep.
You came into our main meeting and now we're still listening.
Sorry. Yeah, no, she was in another life, she was a dealer at Motor City Casino. So, you know,
Oh, stop it.
yeah, for a few months, like 6, 7, 8 months. And then she got in a car accident. She hurt her hand and like had to take time off and then never looked back.
Well, I bet she has stories from that.
Yeah. Yeah. She told me she was dealing once in Ben Affleck, like was filming like Batman here or something. And like she had to deal to just him like all night. Like, you know, nobody else was allowed to be at the table and like you didn't want to switch dealers. And she just had to stand there and deal to Ben Affleck, whatever his name is.
All night long. So was he nice to her?
Yeah, she said that he was fine. She said he wasn't talkative. He just sat there and played, you know, so he wasn't mean, he wasn't nice. He was just kind of sitting there playing.
Doing his thing. God, that's kind of boring. Wouldn't it be boring for him all night long, just sitting there all by yourself?
What, man, it's the people who like gambling though, like I don't understand it. I don't enjoy it. I never have. I guess I'm cheap. Like if I lose a little bit, I'm just like, what am I doing? But the people who like it, like they really like it.
Yeah. Oh, yeah. Nope, not me. I'm like you. I go up north sometimes, you know, when we go up to Harbor Springs, I'll go into the casino there and you're brave. You took 100, I'll take 20. And it's like, oh, this is so stupid.
I know, right?
I'd
Yeah.
rather go buy a really fancy drink for $20 and blow
At least
it.
you get something for it, right?
Exactly.
Yeah. Anyway, how are you? How's things?
Things are good. Life is good here.
When's Judge Martin gonna let you go on vacation? She's still ruling with an iron fist over there?
Yes, she is. She is the most difficult judge I've ever worked for in my life.
Yeah, right. We both know better than that.
I know. I was in Cozumel for 3 weeks, so
Oh,
she
did you
clipped
say
my.
Cozumel?
Yeah,
I
yeah, we
love
go there
Cozumel.
every year. Do you really?
Yeah, I went diving there like a couple times. Back in the day, back before I had kids, that slowed me down.
Oh, yeah. I love it there.
Oh, so do I. It's so beautiful there. And like, you know, it's got the second largest barrier reef in the world outside of
Yeah.
Australia.
Yeah, it's incredible. Yeah, but you know what? I don't know when the last time you were there, but you would be disappointed because it's so populated now.
Yeah.
Yeah, there's a million cars. It just doesn't have the same old charm, but you know,
I'm not surprised. You know,
Yeah.
I think it was just a matter of time because it's got an airport on the island, so you can fly
Oh,
straight to the island, you know.
Yeah, yeah.
Yeah.
All right, come on up here. We're gonna go into a breakout room. You're to talk to your attorney. I'm gonna step out the door while you're talking to the attorney. When you get done, wave if I see you, and I'll come in. If not, you might have to go over there and knock on the door for me. Okay. They open the breakout room, just gotta send this over, okay?
Good morning. Are you both ready to go to the breakout room?
I
Yes.
believe so.
Thank you.
Royce, I'm sorry, did you tell me that you've already spoken to the defendant?
No, no, I still need to speak to him.
Oh, okay, all right. Look at you.
Mary Ann, I've moved him to breakout room 1.
Thanks, Marlisa.
You're welcome.
Good morning, Mr. Hitchcock.
Morning.
Hi, do you need a breakout room with Ms. Standifer?
Man, no, I don't think so. We already have a judgment on this.
Okay, just checking.
This is 200864FY. This is State of Michigan versus Raymond Grant. May I have your appearances, please?
Morning, Your Honor. Royce Nunley appearing on behalf of the defendant. For purposes of the arraignment, we'd waive a formal reading and ask the court to enter a plea of not guilty on his behalf.
Mr. Grant, state your name for the record, please, sir.
Raymond Grant.
Thank you, sir. Were you able to hear Mr. Royce Nunley just now indicate that he's waiving the right to have your charges read into the record?
Yes, ma'am.
And Mr. Grant, you understand why we're here this morning?
Yes.
Today is the day and time set for the felony arraignment. Mr. Grant, you have an absolute right to be represented by an attorney going forward in this felony matter. If you're unable to retain an attorney through your own resources or that of friends and family, the court is able to appoint one for you. Attached to the front of your file is a petition for a court-appointed attorney. The court has signed that. You will be assigned an attorney going forward. It will not be Mr. Nunley. It will be another attorney who uses the information that you provided on this form to be in contact and communication with you. Sir, you also have a right to be considered for pretrial release. The recommendation from Romulus Police Department regarding your bond is dated May 15, 2023, and indicates that the police department does not oppose a personal bond in this matter. Mr. Nunley, any comment as to bond?
We would just ask the court to enter a personal bond. We agree with the police department that he's a good candidate. This is a pretty old case. It looked like from the, couple pages that I got that the offense dates 2018. It wasn't even received by the court until 2020. And now it's 2023. So we're 5 years past it. says that he's been at the same residence for 5 years. Doesn't seem like he's going anywhere. He said he hasn't had any police contact over the last 5 years. It seems like he's a pretty good candidate for a personal bond to me. I would ask the court to consider that.
Thank you. Mr. Grant, the court will adopt the recommendation made by Romulus Police and set your bond at 5,000 personal. You do not need to post any money, but what you must do is continue to appear as directed by the court until this matter is resolved in its entirety. Sir, your next appearance date will be next Wednesday, May the 24th, 2023 at 9:30 a.m. in person in courtroom number 2. Again, this is file number 200864 FY. Next appearance date next Wednesday, May the 24th at 9:30 a.m. in courtroom number 2. Mr. Grant, that means live in person in courtroom number 2 with Chief Judge Brian Oakley. Anything else, Mr. Nunley?
Nothing further, Judge.
Anything else, Romulus?
No, Your Honor.
Thank you. Mr. Grant, good luck to you, sir. Have a good afternoon.
All right, thank you.
This is 23024 ALT. This is Romulus Housing versus Standiford. May I have your appearance, please?
Tequila Standiford.
Good morning, Your Honor. Steve Hitchcock on behalf of the Romulus Housing Commission.
Good morning, Mr. Hitchcock and Ms. Standiford. The court scheduled this matter for hearing on receipt of the defendant's motion to set aside default possession judgment. Mr. Hitchcock, did you receive a copy of this motion?
I did.
Did you file any response, sir?
I haven't filed any written response. I mean, my response though would be that it wasn't a default. As you know, Your Honor, there was a trial on this matter that you held in which you entered a judgment in the amount of $3,418, none of which has been paid as of this time to the Housing Commission. I do note that she, at filing this motion, apparently paid into escrow $742 with the court.
Ms. Standiford, Mr. Hitchcock launched into his response right away. The court typically allows the moving party to present their case. Mr. Hitchcock, has properly indicated that although you filed this as a motion to set aside default, and your motion indicates that default entered on April the 10th, 2023, we did have a full hearing in this matter where you were afforded every opportunity to present witnesses and documents in this case to make your argument.
Yes, I did, Your Honor.
You indicated in your motion that you did not understand the trial, and your landlord also said they would work with you. If I can pay judgment, they will correct my payment amount after I need more time to pay. That is the content. Those are the contents of your motion in its entirety. Ma'am, please explain to the court why you asked to be seen this morning.
Just so that I could have more time to pay off the balance, and I've been arguing the balance. Your Honor, I didn't have the money. What I was able to get a court was from donations from my coworkers. I talked to, like I said before, I talked to the landlord, and I clearly misunderstood what the trial was or how it was supposed to go. They said they would give me more time. I was able to pay that, but I just needed more time to pay the rest. There's no argument about it. Whatever is wrong, she'll correct it after that. I just needed more time to pay it.
Anything else, Ms. Standiford?
No.
Mr. Hitchcock?
Well, Judge, she's had more than a month since the judgment was entered already.
I don't have a job or income. That came from donations from my coworker, sir.
Ma'am, don't interrupt him, please.
I'm sorry.
Mr. Hitchcock?
So as we have indicated, if she can pay the judgment amount and she can establish for us the income level that would warrant a reduction in the rent going forward, we're happy to do that. We don't really want to evict her, but we can't have her living there paying nothing either.
Anything else, Mr. Hitchcock?
No, my understanding is she hasn't provided any additional documents to the Housing Commission since the judgment.
Ms. Standifer, before you say anything else, I want the record to be clear that when a person represents themselves in this courtroom, the court does allow some latitude in how things are presented. And whenever Mr. Hitchcock presented any witness or any evidence, I specifically inquired of you multiple times, anything else? Is there anything you'd like to say? Are there any documents you want to present? You were organized. You responded to questions when you were under oath. The issue was your landlord had attempted to make adjustments to your your portion of the rent based on the income in the household, you being the payee for some others in your house. There were questions about the transfer of funds in and out of your multiple bank accounts. We had a lengthy trial regarding your certification, the calculations of your rental portion. I know it is my practice, and I'm sure I asked you, did you have any questions before I made my ruling? And the court's ruling was based on the testimony and the evidence presented by both parties. That being the case, this not being a default judgment, but a judgment after hearing, the court will deny your motion to set aside the judgment in this case, will find that you have failed to set forth either good cause or meritorious defense. After receipt of your motion, the court did receive an application and order of eviction from plaintiff's attorney, Mr. Hitchcock. Does your client still wish this order of eviction to be signed and entered?
Yes, Your Honor.
Any comment, Ms. Standifer?
I did make, Your Honor, I did say, and when you asked me if I had any questions, I said, so that means that I'll get more time to pay it. As long as I can come up with the money to pay it, they'll correct it. And that's exactly how I asked. That was the last question I asked, and I was told yes. I did also present the forms. The day that I was in court, I sent it the day before, and then I also went the day of when I left the courtroom to take her all of the documents she asked for, because she wanted it in a particular form, and she helped me do it that day, Your Honor. And then I came and I gave the 742 that I did have. I just needed more time to pay. I'm not even arguing the balance or anything, but I did say that I didn't understand. When, at the end, I said, so that means that I'll get more time as long as I pay it. And I was told, yes, that's what I asked. That was my question.
That question comes up frequently in non-payment of rent cases, and the court's usual response is, by law, it's 10 days to pay. The court does not get involved in how you make payments to your landlord or how they accept them. Mr. Hitchcock indicated that his client will be willing to have conversation with you. Again, that is something that is outside of the court's purview. It is 10 days to pay or vacate the property. Mr. Hitchcock has indicated that in the 5 weeks now since judgment entered, you have not paid any amount. Based on that, the
$800
application for order of eviction that was filed on April the 24th, 2023 indicates that judgment entered on April 10th and that no payment has been received to this point. The court is signing that order of eviction, ma'am.
That was, what was the 742 for? My lawyer told me to come and pay that. And that's why I had the form, because I got a lawyer through the state. They told me that I had to file a form and send the landlords 1 month rent is what they told me I had to do. And so that's what I did once my coworkers gave me the donation. I guess I misunderstood that. I thought that was me giving them at least 742 of the dollars so that I can have the conversation to pay more, Your Honor.
The 1 month rent was deposited based on the fact that the judgment entered on April the 10th, and you did not file this motion until April the 25th. That was part of setting aside, or your motion to set aside the judgment.
Right.
It has not been released. It has not been released to the plaintiff as of yet. It was more of a placeholder as this motion was scheduled and now heard.
Right. I came in before my time was up and I spoke to the clerk and he misinformed me. So when I came back, I spoke to the same person, and that's why she came up and tried to help me out, because she misinformed me for what I was doing. Well, he did. And then his manager came down and talked to me about it.
There is notice that the court staff does not give legal advice. They cannot give legal advice. They are not attorneys. They are not your attorney. Anything that they can, the thing that they can give you are the forms that you request. And when they would have directed you to legalhelp.com, and you've indicated already on the record that you have an attorney. Ms. Standifer, the issue is you have not paid the judgment that entered back on April the 10th. When we were in court, you presented documentation that showed that you had income coming into the house You indicated that your, I don't remember if it was husband or ex-husband, helped you from time to time. So how you pay it, if you pay it, is an issue between you and Romulus Housing. The court doesn't get involved in that. The court gets involved in hearing motions and ruling on them. You filed a motion that indicates that this was a default. It was not. You filed, in your motion, you indicate that you didn't understand what was going on at trial. And this court is sensitive to people who are representing themselves and ask multiple times, is there anything else? Is there anything you want to say? Is there anybody you want to produce? So your motion is denied. The court cannot give you more time based on what was contained in your motion. Mr. Hitchcock's request for execution has been signed in as much as it's now been 5
Okay,
weeks and you have not paid any amount.
I'm sorry. Well, I completely did not know what's going on. And I thought I was paying them. I thought I had to go through the court to pay them. Like my lawyer told me something totally different. I was waiting on the court appointed lawyer who got with me. Anyway, Your Honor, I don't know. How much time do I have? And what did I just waste $800 for nothing? I thought that went to my landlord.
It will go to your landlord because you owe the money.
Right. And I thought that was
the court. Go ahead.
And I thought that was what I thought I had to go through the court to pay them, because when he said the conversation about it, I went over there the same day. If she had just told me, okay, so pay 1 month and then we'll do this. That was the conversation she had with me. If that was the conversation she had with me, that's what would have happened. I would have came to the court to pay money. I would have went to the Romulus Housing Commission to pay money and to sign paperwork to pay whatever else. That makes no sense to me. Why would I just bring any paperwork? The lawyer told me to file all of that. I had no idea.
Ms. Standifer, I don't know who you talked to. There is no lawyer who's filed an appearance in this matter. I conclude non-payment cases the same way. Be in contact and communication with your landlord because they only allow 10 days. Anything beyond that is something that you have to negotiate with your landlord. That is what I say, because this court does not get involved in making payment arrangements. If you had taken that $700 to or $740, whatever it was, to Romulus Housing, they may have had a different conversation. If you had a plan with them regarding a plan with them regarding payments on the balance or recertification or proof of income or better explanation about the deposits into your various accounts, you could have a different conversation. I know those facts because you had the trial here, but the court does not get involved in how a tenant pays non-payment of rent cases. I have signed the order, but again, it is between you and your landlord what happens next. The court does not get involved in that. Mr. Hitchcock's client might say, based on this money, we'll get into an agreement, or ask his client to have contact with you, or might just say, no, we have our order. We want to retake our premises. This court does not know and is not involved in it. And ma'am, I feel for you right now, but the court's hands are tied in terms of how to proceed when there was a judgment after trial and you haven't paid it.
Right. And I can understand that. That's how it was supposed to go. And the lawyer that I have, I'm going to get on the phone and tell him, like, he told me to do the wrong thing. He had me draw paperwork, take money somewhere else, and I could have just took it to my landlord. I had just left my landlord before I came down there.
Anything else, Mr. Hitchcock?
I would just ask that, can we have a release of this $742 that's in escrow to the Romulus
All
Housing?
right, I wrote that in the file that the escrow is to be released to you.
Thank you.
Thank you.
Ridiculous.
That concludes this matter.
Thank you. How much time do I have to move?
The court has signed the order. It will go to the court officer, and then it's on the plaintiff how they direct them to come to the premises.
Thank you.
Thank you.
Thank you, Judge.
You're welcome, Mr. Hitchcock. Have a good day.
You too.
You can't go nowhere anyway. Okay. Security. You make more money, right? Probably.
we're not ready. Mary Ann, it's fine.
This attorney got his first job working for Pete Trail Day
Really?
40 years ago. He knows what I'm worried about.
Please get your court officer. I know. I thought that I was no longer going to have to wait for people, yet here I am waiting for people again and again and again and again. Good afternoon. Good morning. Would you come up to the podium for me, please? This is 231116 LT. This is Kirkridge Park Cooperative versus Joyce Frierson. May I have your appearance, please?
Yes, good morning. Michael Hurley on behalf of Kirkridge Co-op, Your Honor. My P number is 37519.
Thank you, Mr. Hurley. Today is the day and time set for hearing on this matter. The parties were last here on April 28, 2023, at which time we adjourned the trial to today at 11 a.m. The defendant had previously had some technology issues. The court indicated at that time that Ms. Frierson should use this adjourned time to work out her technology issues or appear live in this courtroom or downstairs in the court Zoom room. This case was scheduled at 11 a.m. by consent of the parties on April 28th. It's now 11:18 by this court's clock. You are here on behalf of the plaintiff. The defendant is notably absent. Has there been a resolution of this matter?
No, Your Honor. We'd ask the court to enter a default judgment for possession only, I believe. I have a dollar amount, but we'll submit paperwork on it, but the dollar amount should be, as I have it, $3,369, Your Honor. That includes background late fees and then legal fees of $164.
The 164 is already added into the 3,369.
Yes, yes.
This matter having been scheduled at 11 a.m., it now being 11:19 a.m. by the court's clock, defendant having failed to appear, the court checked the register of actions before calling the case. There's no one in the court's virtual courtroom, no one in the court's virtual breakout rooms. Ms. Frierson having failed to appear, plaintiff's motion for entry of default judgment will be granted. Mr. Hurley, your office should submit a default judgment that shows a total of $3,369 owing payable within 10 days. Anything else on behalf of Kirkridge?
I'll submit this electronically, Your Honor.
Absolutely. If you want to do it downstairs, the file will be downstairs shortly. If you want to do it electronically, that's fine as well.
Okay, very good.
Anything else?
No, I think that's it. I just want to say this is my first time in the court since the new building is spectacular.
They did a great job.
Yeah, this is impressive. Very nice. Very nice.
Enjoy the rest of your day.
Thank you.
Thank you. That is the last case we have scheduled. I have not received any additional information from our Lisa regarding arraignments. We will stand adjourned. Thanks, Ken.